appeal in the matter of the Royal Parks Ltd and Boohene and others.
Yes, Mr. Khan.
My lords, good morning. I appear together with my learned friend who sits immediately behind me, Mr. O'Keefe, for the appellant, who were the claimants at first instance. My learned friend, Mr. Milford, appears for the respondent.
Yes.
Can I start by apologising if I held up the court in any way? I had to
You did.
struggle to...
Apologies not necessary. I gather that there was a very long queue because of another case that's taking place.
I'm grateful.
No apologies. Do carry on.
Thank you. My lords, can I start by checking whether the court has three bundles? A core bundle, a supplemental bundle, and a bundle of authorities.
We do.
Thank you. My lord, can I also check my understanding that in principle, although we may not take the full allotted 1.5 days, the court's prepared to sit until lunchtime today and then for a full day tomorrow.
Yes, I'm sorry if it turns out it could have been a day. That's annoying that it's been split, but I had other commitments late afternoon, so I think the sensible thing is to break at lunchtime.
Thank you.
Mid-afternoon, I should say.
My lord, what I had envisaged, and of course I'm open to your views and also to the views of my learned friend, was that I would take up most of today setting out the...
Most of this morning, you mean?
Yes.
Yeah.
Most of this morning setting out the appellant's case. If I finish early, then of course my learned friend is welcome to start if that's appropriate. And then tomorrow I might reserve myself a short right of reply on points of law raised in my learned friend's additional reasons.
Well, hang on.
Yeah.
As long as we finish by 4:15 tomorrow, I don't really mind how the time is allotted, but broadly speaking, you've got half of it each. Yeah. However, there is a point which we're relaxed about as long as everyone knows what's happening. Are you proposing to deal with his respondent's notice points first time round, or deal with them only in reply? I haven't actually discussed this with my lords. On the whole, that tends to be less satisfactory. Although I see the logic of saying the respondent's notice points, so you'll let him develop them first. You've seen his skeleton argument.
Yes.
It might make more sense for you to deal with them first time round. What were you planning to do?
My lord, I was planning to take that approach.
Yes,
to deal, as we've done in our replacement skeleton, to deal with everything in a joined up way.
Yes, you did. No, that's fine. And good. Okay. Well, then you'll take as long as you take. Obviously, if you haven't finished by the end of this morning, that's by no means the end of the world, but we'll be wanting to know how quickly you'll finish the tomorrow.
Thank you, my lord. The only thing I was...
Yeah, can I just say one more thing? Obvious, you all know it. We have actually read the papers and read them pretty carefully, so elaborate exposition merely to set the scene is not necessary.
I'm grateful for that indication, my lord. Could I just say, and forgive me if I'm repeating a point, but although I propose to deal with the additional reasons today, if there is something in my learned friend's oral submissions which I haven't anticipated on the additional reasons, I might reserve myself the right for a
it's not a question of reserve. You have one, whether you reserve it or not.
So, my lords, without further ado, before I delve into the detailed grounds of appeal, just by way of brief overview and not elaborate scene setting, we ask this court to restore the decision of the Employment Tribunal and to overturn the decision of the EAT. And although our primary focus will be on the ET's judgment and reasons, and explaining why the outcome reached by the ET was the just outcome, and why its decision is, on the whole, good, I also feel it's part of my job to engage with some of the alternative analysis and the criticisms made of the claimant's case by the EAT. I think it's part of my job to explain to this court why, with great respect to Mrs. Justice ED and members, we feel that she took a wrong turn.
Yeah. Well, obviously, I mean, frankly, I thought that should be your main focus, because obviously you need to defend what the ET said, but you need to defend it against the criticisms made by the EAT. So that's ultimately where the focus will be.
Yes.
Yeah.
And just so you know what's coming when I develop the argument, we'll say that of the EAT's decision, that number one, with respect, the EAT didn't quite appreciate the full circumstances in which the arguments unfolded at first instance. And so it reached, in my view, an unfair and a slightly harsh assessment of the claimant's case.
Perhaps that's the pleading point.
Yes. We say the EAT was not, with respect, correct to say that the claimants and the tribunal tried to shut out relevant people from the pool of comparison. Secondly, we say that while the EAT may, 2 years after the trial decision, quibble with the precise formulation of the PCP which the ED adopted, it really makes no difference to the outcome. What we will say is whether you take a narrow lens or a slightly wider angle lens through which to view the facts, your focus still comes to rest on the same pool of 150 employees, 160 employees and 50 contractors, which was the pool that ET used to test group disadvantage.
How many contractors?
50. My lord.
Does the evidence demonstrate how many contractors there were across all the outsourced workers of
My lord,
Parks?
no.
We can infer from the figures that the number of outsourced workers other outsourced workers was larger than the number of those on what's described as the toilet and cleaning contract.
Yes, there are certain indicia in the evidence which
Yeah.
show that there were other contracts.
I agree, we haven't got figures. Can we just take one point of terminology out of the way?
Yes.
If you look at the facts, it's sort of described as though your clients simply worked as, the facts as found by the ET, as toilet attendants, but it's also, they call it the toilet and cleaning contract, and you call them the park attendants.
Yes.
Obviously, this doesn't affect
Yep.
the legal issues we have to decide, but just so we describe them correctly, what were they doing?
So cleaning public toilets, also picking litter.
So those are the two principal tasks.
Yes.
The park attendants is a slightly, suggests a slightly broader role, and it's not quite the right label, is it?
My lord, yes.
Okay, thank you. And just one other question, again, only as background. UVW, if I can call them that for short, were not formally recognised for collective bargaining. Well, I suppose they obviously weren't with Royal Parks. Were they recognised by Vinci?
My lord,
No. Okay, thanks.
And at page 110, paragraph 29 of the ET, is that an accurate description, broadly, of the range of functions that were the subject of outsourcing?
I could just have a moment, my lord.
Yes, certainly.
My eye on
The
this.
service functions that have been outsourced, fourth line of paragraph 29, page 110. include the cleaning and maintenance of toilets, which are your people,
Yes.
landscape maintenance and horticulture, which I tend to think of as gardeners, gate locking, which we would tend to think of as park attendants, and building and maintenance repairs. There seem to be 4 major groups referred to there, but there may be others.
Well, one other that maybe is not quite the same, but is clearly mentioned in some of the correspondence that's quoted,
Catering.
cater people around the canteens.
The concessionaires.
Yes.
So, my lord, my clients have no first-hand or direct knowledge of who other outsourced workers were or what their functions were.
No.
What we know is based from, if you like, a slither of disclosure which came through during the final hearing, where there were indirect references to other contracts.
Yes, but we don't. It's the trouble with setting the scene submissions. We tend to get stuck in too early into the substantive issues which you're going to come to. But just to flag it up, the EAT does say, unless you show us otherwise, if you had chosen to try and find out more about the other outsourced workers, there are procedural mechanisms for doing so.
Yes. Though I say here the context and the point at which these other outsourced contract workers come to our attention is important. Documents which, and the reason why we've included our closing submission to trial, because they clearly show what was disclosed at the end of day 2 before the trial, etc.
Okay, well, you're going to. I will resist the temptation to ask you to develop that submission now. We'll come back to it. Yeah. Sorry. Yes, you'd made your 2 basic points about the EAT, or perhaps there were going to be more, but one, they didn't appreciate the circumstances in which the arguments unfolded in the first instance. The second, that although they, as you put it, were quibbling with the principal formulation, it doesn't actually affect the outcome.
Lord, yes.
Anything else?
The third and final point is that we say the ET's decision should be upheld and it's the right outcome. But if we're wrong on that, this was not a case where the EAT should have or could properly have exercised its discretion to substitute its own view. And we say, even if the EAT is right that there's an error of law which requires justification, to substitute your own view is an oversteer or an overcorrection.
Yeah. Okay.
My lords, the order in which I propose to deal with the substantive issues are essentially set out in our replacement skeleton, starting with the Section 41 Equality Act point on material scope, moving on to the issue of the principal formulation of the PCP, that's number 2. Number 3, dealing with the rule, and I appreciate issues 2 and 3 shade into another.
This is set out in paragraph 7, which I find particularly helpful. I'm going to hazard that it's page 33, but I have no idea where it really is. 31. Thank you. Are you following that?
My lord, yes, it's page 31. 31, yes.
Paragraph 7.
And the final 2 points are going to then be to deal with the so-called material differences which the respondent relies on in its additional reasons, and the issue of if there's an error of law which requires intervention, what's the right thing to do? Is it remittal or something else?
Sorry, I didn't in the end write those down, but there's 5 points, and
so
okay,
materials.
well, I'll just note them down as we get to them. So we're about to start with 1. What was the proposition in 1, or the area you're covering in 1?
Material scope of Section 41 of the Equality Act.
Yes, I see. Thank you.
So my lords, our headline submission on this point is that both the ET and the EAT reached the right conclusion, which was that this case fell within the material scope of Section 41. And this is really a conclusion based on substance rather than form, which is a point I'll develop. My lord, please stop me if I'm boring you with facts you've already mastered. We say the findings of fact by the Employment Tribunal were stark, and they showed that the respondent exercised a peculiarly close degree of control over the minimum rate of pay for the claimants. A convenient reference for your lordships is the EAT's judgment. It's core bundle, tab 7, page 84, paragraph 71. This is a long paragraph, but if I may just pick out a few things in this paragraph which refer back to the ET's findings of fact. And the first, which is in the first 4 lines, is that really the respondent was presented with 2 bids. It was in the driving seat, and it chose the bid which was the national minimum wage, not the London living wage cost of bid. Second finding of fact, which is around or just over halfway through the paragraph, with the line starting with the words starting levels of pay within the price agreed, but specifically challenged the contractor on the hourly rate. So the Employment Tribunal found that this was a respondent who was exercising very close oversight and pushing back on hourly rate, not on price globally, but on hourly rate in individual workers. The third salient feature is a couple of lines further down, where it says, more than that, the respondent's predecessor had expressly reserved the right to revisit the issue of minimum pay rates at LW levels. And pausing there, my lords, apologies if you have already seen this in your reading, but in the supplemental bundle at page 39, you have a very brief 3-page contract.
I hadn't actually looked at this because I thought it was all sufficiently set out in the ET, but if there's something special you'd like us to look at, we of course will.
Grateful. I should say more precisely, this is a letter which sets out or which clarifies certain terms in the contract between Vinci and Royal Parks. And over the page, at page 40, 3 entries from the bottom is number 6, London living wage. This option, this is the Royal Parks writing, this option will not be taken up for the moment, but TRP reserves the right to revisit this at any point during the contract period. And I'm referring to this is Justice Eady's or the EAT's reasons. Full bundle, page 84. And it's the final sentence of her paragraph 71. And she explains that it was the respondent's decision to, if you like, reverse its election and then move to LLW rates. My Lord, in order to avoid duplicating the argument, I can give you the references to those findings in the ET's reasons and really
Yes,
they
thank
are
you.
core bundle tab 9, page 112, paragraphs 34 to 37.
Sorry, that's your first point.
Um,
I'm
So all 4 points are covered in the following 2
yes, I see.
references.
Okay.
So, my lord,
Which paras you say?
paragraphs 34 to 37,
Yeah.
and then the conclusion at paragraph 64 and paragraph 68. That conclusion being that
Well, there's also, yes, I see. There are also some other, for example, there's a reference in the very last line to paragraph 50, very last line of the EAT.
yes, my lord.
But no, that's how you're being helpful.
Yes, my lord. That's to do with the final point of moving the rate from
Yes,
NMW to LLW.
yes. Thank you.
Well, I won't go further with the EAT's reasoning on this point, but I say the ET and the EAT essentially shared the same view. Take a step back and you ask yourselves, what's really going on here? What's the formal position in terms of the contracts, and then what's the substantive position?
You're going to take us to Allenby in due course, eh?
My lord, yes.
Yeah.
And if the overarching question is who really determined, who effectively determined the minimum rates of pay, say on the evidence, the answer is the respondent. Allenby, my lords, I will take you to in a moment, but before I do that, I may take you to the statute. I was in the authorities bundle at tab 4. Which is page 8. You have the section 41, and in particular, my lords, I'm going to address you on section 41, subsection 1A, and subsection 1D. Lord, I say subsection 1A prohibits discrimination, as it says, in respect of the terms on which the principal allows the worker to do the work. And I suppose the difference between my learned friend and I here is how you should construe the verb to allow. And my learned friend would probably ask you to take a very narrow reading. To allow means to permit. So to allow versus to disallow. Lord, my lords, I'd invite you to take a broader meaning. To allow really means in this context to enable, or to, I hope I'm not stretching it too far, to make available work. And I will come to Allenby in a moment, but sticking with the statute, the words of the statute, clause 41(5) gives the definition of a principal as someone who makes available work for an individual. I say it's in that context that we have to construe the words allows.
If you're employed by another person, then I'll start again. If you're a direct employee, then it's inherent in an employment contract that you will be given work. You have a right to work.
Yes.
But that sort of language can't operate in a field where there are contract workers, because there's no employment contract with that inherent. feature. Is that your part of your contrasting
Yes,
process?
my lord. Yes, the language I think is broader because it has to be broader to fit the situation.
And there's no, if you're an employer if you're a body who is outsourcing work, then you have no direct employment relationship, and so therefore you can neither compel somebody to do work,
Yes.
nor have they any right as against you to have work.
Yes, and I suppose if you look at the converse, you don't have a right to, well, in many cases, you wouldn't have a right to exclude someone from the workplace. What technically you might do is say to the contractor, Vinci in this case, we don't want Mr. X coming here anymore, and then Vinci excludes Mr. X or tells him you're not turning up for work today.
I wonder if the words make work available really helps, because if one looks at 5, subsection 5, a principal is a person who makes work available for an individual who is A, employed by another person, and B, supplied by the other person. And in most instances, the fact that a person is employed by someone else means that the terms of their contract of employment will be fixed by someone else. And the reality you say here is that the pay part of the contract between Vinci and the individual is actually set by the principal, not by the actual employer. The work is made available,
Yes.
the parks and the toilets and so on, and the cleaning, but the employment terms unusually are not fixed by the subcontractor, but are fixed, you say, in reality, by the parks people. And that, you say, has to be brought into the word allow.
My lord, yes. I suppose you have a situation here, and trying to use the word allow in the analysis, I would say the Royal Parks here made certain work available, allowed people to do the work on certain terms, on the term that their pay would be a minimum, well, that their minimum rate of pay would be the national minimum wage.
Because the reality you say is, when you look at 1A, as to the terms on which the principal allows or permits the worker to do the work, unless Vinci caves in and pays a lower rate, they're not going to take the contract and they're not going to be able to do the work. That's what you say. It's more to do with allowing the facts rather than make available, I think. But that's your case, really, isn't it?
I know, yes. It's the substance over the formal contractual position.
And so it would not be possible, just to pursue the point I was trying out earlier on, for one to manipulate 41(1)(a) to say that there mustn't be any discrimination against contract worker as the terms on which the principal requires the worker to do the work, because the principal can't require the worker to do the work.
Oh, yes, I agree respectfully.
So this will be the exceptional case. In most instances, it's not going to be a problem. Contracting will be outside because the terms of employment are fixed by the normal route of the employer deciding what to pay, and the contractor may or may not even be interested in that, so long as the bottom line is low. But where the ultimate per park person rolls their sleeves up and gets involved and says, I'll only give you the contract, these people can only work here if you agree to pay them the lower wage, not the London rating wage, that, you say, is an exceptional circumstance, which is what 41 is intended as a statutory purpose to achieve, and the wording is flexible enough to accommodate that, is your case, I think.
My lord, yes. I say that the facts here are peculiar, and this is a situation where you have a respondent who's hovering over the contract, negotiating not simply the global price of the contract, but zeroing in on an individual's hourly rate. My lords, may I take you to Allenby, or is there something else?
Are you going to come back to D?
Yes. Grateful.
Okay.
So on D, my lords, what I say the most natural fit for the facts of this case is A, but, and this is simply a fallback position. D seems to be a catch-all, any other detriment, and we say here that the respondent's actions in doing the contractors out of the LLW rate visited upon them a detriment, and that, in my submission, I say that the causal link is quite clear, and it amounts to subjecting them to any other detriment.
Would that be true in any case where a principal set a price for a contract, the inevitable implications of which would be that the employer would have to pay less than they would otherwise pay?
No, I don't go that far. If the negotiation between the Royal Parks and Vinci had proceeded purely on the basis of the global price of the contract, at that high level of detail, then I don't say that would be a case that flies.
So it is specifically the circumstance here of Vinci having offered two prices, one LLW based and one not, and Royal Parks having made its choice. Yeah.
Yes. And then the Royal Parks having been, the hourly rate being singled out for specific attention, for special attention, in the way we've seen in the letter which clarifies the contract terms, and reserving itself a contractual power to revisit.
It's not just general hovering, it's focused hovering.
Oh, yes.
It's a decision not to give to the contracted workers the guarantee or commitment to the London living wage that they give to their own workers.
Yes.
All right, but that rather begs the question, doesn't it? This is the point we're going to look at in Allenby. They're not actually saying, we're not going to give you the London living wage. They're merely saying, we are not going to fund Vinci to pay the London living wage and still make a profit.
Yes.
It means in practice, Vinci won't take the work.
Yeah.
Okay, thank you.
And of course, the different ways of characterising it, but I say here the consequence is so immediate, and the election on the rate is so has such a direct impact on the hourly rate that it's, I say, the fair and permissible way to characterise that fact is as the EAT found. And
Yes, thank you. You're going to take us to Allenby,
Allenby,
weren't you?
yes. My lord, that's in your authorities bundle, tab 7, starting at page 57. My lords, as you will note, this case, or the bit which I'm going to refer to, discuss like Section 9 of the Sex Discrimination Act 1975, like one of the ancestors of Section 41, the Equality Act. And perhaps working through selections of the judgment only, at paragraph 3, it's page 62. You have here a brief summary of some of the facts, and 5 lines from the end of the paragraph, you have only a single sentence which describes the facts regarding how the pay came to be set for the contracted workers. Simply says their pay became a proportion of the fee agreed between ENS, that's the agency and the college, that's the outsourcer. We have no further detail about whether the college, whether there was any, to use my lordship's phrase, focused hovering over the rate, hourly rate of pay, or whether there was any closer degree of involvement. My lords, I say,
We don't get any out. I notice you've put in the EAT decision, which
Yes.
I didn't look at. You don't get any more detail from that.
I've checked it briefly, and my learned friend will please correct me if I'm wrong, but I don't think there is anything specific, more specific in the EAT judgments. I think you have 2 or 3 judgments in related matters combined, one following the other.
So no further detail in the EAT or the ECJ, as it was. Right. Okay. Thanks.
Lord, I'll have to double check the ECJ, and if the position is different, I will.
Yes. No, that's fine. We'll unless you tell us otherwise. That's the basis. We have we got the ECJ decision here? Yes, we have. It's further along. Yeah. Okay. Don't waste time on that for the moment.
Okay.
At the moment, as you understand it, the single sentence you pointed out is the nearest we get to. Is the only thing we have on the facts. Yep.
So, my lords, I'm going to, if I may, take you to paragraph 34, page 70. It's under the subheading, has there been discrimination against the applicant as a contract worker? 33 sets out the provision there, which I say it's not identical, but for all intents and purposes mirrors from a sex discrimination point of view, section 41. And if I could just focus for a couple of moments on paragraph 34, what Lord Justice Sedley is saying, I say in his opening 3 or 4 lines, he's talking about the purpose of the prohibition against contractor workers. And he says it's there to prevent employers from avoiding the effect of the earlier provisions of that part by bringing in workers on subcontract. So I say the purpose of this legislation, and certainly the purpose of section 41, really it's an anti-avoidance measure. He goes on to say if an employer could get around anti-discrimination law simply by engaging on a contract, not an employment contract, people whom it wished to discriminate against, then the purpose of the statute would be substantially undermined. And his final sentence in 34, it would be particularly remarkable if this were permitted by legislation which treats the principal's own contracted labour as employees. My lords, if we let those final words sink in, I say that discrimination law here treats contracted workers as if they were the principal's own employees.
You have to read that in context, and this is the context where the argument was it only works if you treat some of the workers from the contractor as subject to one set of terms and another set of workers from the same contractor as subject to a different set of terms. Yeah. And the judge was saying, no. If you've got people coming to your workplace as contracted workers, you can also compare them in relevant circumstances. Yeah. Paragraph 35 is all about for the purposes of discrimination law. But you can't then take that and use it to the context that we're dealing with.
So, my lord, paragraph 35, which I'll go on to now, you're quite right, says that there's only this like a cross comparison between employees and contracted workers only works, quote unquote, so long as they are working for the same principle. And then, although it's not explicitly said here, I also accept that they've got to be in the same material circumstance. My Lord, on page 71, continuing with paragraph 35, we have here a glimpse into, this is no more than a glimpse into the facts regarding the pay arrangement. Lord Justice Sedley refers to the Appellants Council and says her problem, however, is to show that in the present case, the principal, that's the college, is discriminating against the applicant when it uses her services through ELS. It is ELS, says Mr. Jeans, against whom the applicant's complaints lie, because it is they alone who set the terms of her employment. And in the following paragraph, Lord Justice Sedley says this is largely but not entirely true, and the point of difference she goes on to mention are, if you like, certain fringe benefits such as insurance and career development, but there seems to be no dispute on the facts that it was indeed the principal who set the terms of her employment, barring the examples.
Right, so if we had something akin to what happened in the present case, that would inevitably have been discussed in these paragraphs.
My Lord, yes.
I mean, the impression I get from these paragraphs is that this is a situation where the money that the worker got was determined by the contractor, ELS. They paid a proportion, they had people on their books, they supplied them, and there was a fee paid to the contractor and the worker got a proportion.
Yeah.
The user, the principal in our case, wasn't involved with the fixing of the proportion that the worker got at all. And that's why, and I imagine you say it's critical, that it says that it is they alone who set the terms of the employment. If the contractor set the terms of the employment, then the principal wouldn't be discriminating. And here it is about those other things that the principal, not the contractor, determined. But you say your case falls squarely within the words, because it is not the contractor who sets the terms of the employment. So far as pay is concerned, you say the person who effectively sets the terms of the employment contract is actually the principal, not the contractor. That's your case, really, isn't it?
Yes, my Lord, it's exactly that. You have if you like, a slightly strange situation where a party who is not privy to the contract is nevertheless calling the shots and effectively setting the terms. My Lord, unless there was something else in Lord Justice Sedley's judgment which you specifically want me to address, I was going to move on to the judgment from Mr. Justice Gage, and in particular paragraph 73, which is at page 79, at the bottom of 79. Now, before I dive in, I'll readily accept that there's something of a difference between Mr. Justice Gage's comments and then Lord Justice Ward's comments, which we'll come to.
Well, there's also something, I think, isn't there, between Lord Justice Sedley and Lord Justice Ward? Maybe not. Let's keep going.
Mr. Justice Gage in 73 is agreeing with Lord Justice Sedley, and then the sentence, which I say with great respect to that judge, goes too far, is his comment starting at the top of page 80. I further agree that where a complaint is made about matters which are essentially contractual, a complaint, if any, lies against the employer and not against the principal, as defined in section 9.
But isn't that the same as Lord Justice Sedley? He certainly thinks he's agreeing with him. He says, I agree that.
Yes, so you're right. He says that
It depends on how you read contractual. It's not contractual in the sense of, or is it included in the contract? He means contractual because at the back of the judge's mind is the terms of the contract will normally be fixed by the contractor and the worker.
Yes.
Yes.
Lord,
But I think what you have to say about both Lord Justice Sedley and Mr. Justice Gage is that they were making the not unreasonable assumption, certainly it was the facts of their case, and it would be the normal case, that the contractual terms are always properly to be regarded as set by the contractor.
yes.
Neither of them had in mind a case like the present, and therefore it can't be said to be, when they use language like this, they can't be said to be directing their minds to such a case. But I don't think it is just Mr. Justice Gage. I think it's both of them.
Yes.
You have the help in Lord Justice Sedley's thing of his phrase, they alone. But I think actually Lord Justice Sedley was assuming that would always be the case.
Yes. Well,
Anyway.
yes, it's the intervention of a non-party to set the terms, which
Yes.
makes our tax different.
Yes, no. Well, I see exactly how you put it.
My Lord, if I may move on to Lord Justice Ward's judgment on this point. And this is the relevant section is at page 83. Paragraphs 88 and 89 in my submission lend weight to a propositive approach.
So sorry, which paragraph were you talking about?
Paragraphs 88 and 89.
Right.
And Lord Justice Sedley at paragraph 89.
Or Justice Ward, you mean?
Sorry, Lord Justice Ward says there halfway through the second line, the purpose of the Act does not require such limitation. On the contrary, so restricted a meaning defeats the primary purpose of the Act, which is to remove sex discrimination of any kind in the employment field. I say it's important to bear in mind what the primary purpose behind the legislation is when interpreting the words. And I say, I mean, realistically, we're living in an age where outsourcing and atypical working is becoming more and more commonplace. So I would invite this court to give Section 41 a scope which is in line with its protective purpose. Paragraph 91 and paragraph 92 are where I invite the court to take a closer look. And picking up paragraph 91 towards the end of the third line, as it seems to me therefore that the proper question for the tribunal to be asking is whether or not, in relation to the work available for doing by the contract worker, in this case the teaching, the college has applied a discriminatory condition or requirement in the terms on which it allows her to do that work, or in the way it affords her or denies her access to any benefits, facilities or services. That is very much a common sense, fact-based inquiry, and therefore very much one for the tribunal to undertake. And I say that in our case, respectfully, the ET took a common sense, fact-based approach, or as Mr. Justice Eady put it in the AT, looked at the real world impact of the respondent's involvement. Paragraph 92 Lord Justice Ward gives his view on the weight to be given to contractual arrangements. And I suppose his basic point is midway through the paragraph. In my judgment, whilst the contractual arrangements are very relevant, they may not be determinative. And here I say the tribunal was quite right to focus on the contractual arrangements and how the term regarding minimum rate of pay.
Isn't he? But again, he no more than the other two members had this sort of situation in mind. That observation is really saying, I think, that the fact that the contractual arrangement is between the worker and ELS doesn't mean that there are not some non-contractual benefits which the college has the power to withhold or to treat them differently from their own employees. And if that happened, it doesn't matter that there's no contractual relationship between the college and the worker. So I'm not actually sure, looking at it, that it's that different. I know Mrs. Justice Eady said there's a tension between Lord Justice Ward and Mr. Justice Gage, but I wonder if they aren't all saying the same thing. Because just remind me, what were the actual benefits about which the complaint was being made?
In this case,
Yes, in
I
Allenby.
think it was professional indemnity insurance and career.
Yes, because it wasn't about pay at all.
Yeah. Well, we're coming on to an equal pay claim just in the next couple of paragraphs, which may be a separate
Yes,
issue, you can see.
yes, but the equal pay claim failed.
Yeah.
Because they weren't in the same employment.
The problem is, in this judgment and in the EAT judgment, we don't have the magic 1A, B, C and D that Gage, J and Sedley LJ are referring to. So it's very, very difficult, and they're not in the head note either.
Yeah.
But it looks as if it's things other than that which was determined in the contract between the contractor and the worker. It looks as if they were things available in the college generally, which may or may not have a contractual part, such as would they be insured, if they had an accident there, and could they eat in the canteen, or were they told, get thee gone, thou art not a worker.
Yeah.
That seems to be the implication of it.
Yeah.
And the pay seems to have been done differently, because it seems to have been accepted that the pay was fixed by the contractor, and the question was whether you could compare the contractor's pay rates with the pay rates of the person who owned the place where the work was done.
Yeah.
That seems to be the thrust of it.
On which she lost, yes.
Lord, I say if the main point, my respectful submission to take away from Allenby is it's for the tribunal to take a common sense view of the facts and ask when you're interpreting section 41(1)(a, who is determining or effectively determining the terms on which the worker is being allowed to do the work. And I say, with facts as stark as the ones we have before us, if my learned friend was right and said this falls outside of section 41, then it makes that provision toothless in all but the most flagrant or obvious of cases. And it doesn't fit with the purpose behind that.
I'm just reminding myself how Allenby went on pay. They actually referred to the ECJ, didn't they?
Yeah.
Oh, that is backwards. And the ECJ said comparison not possible because they had different employers. Yeah.
Lord, that's our primary case on section 41. In our skeleton, we do make an alternative argument based on or by reference to concept of single source in equal pay case law. I don't say that applies directly, but I say it's something of a helpful yardstick or cross check. And
just to spell this out, I used to know this backwards, but I just need to remind myself. The reason that the claimant lost on her equal pay claim in Allenby was that the ECJ said that the pay of her comparators, which were, was she comparing herself with lecturers who were still employed?
yeah, directly employed.
Yeah, the pay of her comparators and the directly employed comparators and the part-timers was set by different people. And therefore it wasn't the single. That's where the phrase single source comes from. It actually comes from an earlier case on not on another contracting out situation, which is Lawrence. And that phrase single source has popped up in the case law quite a lot thereafter in the domestic case law because it reflected what Luxembourg had said was the central concept, and it's been applied in different types of cases. But in contracting out cases, the law hasn't moved on since Allenby and Lawrence, has it?
Well,
No.
no.
Okay, so just remind me, how do you formulate your alternative way of putting it?
16 to 19 of the skeleton argument.
It's page 3, page 77. I mean
The two, I mean, I was in Asda and Brierley. What did we say there that's helpful to you?
I'll say that's your authorities bundle. Take you to it. Okay, tab 24. And it's really paragraphs 107.
Oh, and so was my lord. I'm embarrassed to have forgotten that. Which paragraph did you say?
107. Lord. So it starts at page 423.
Oh, I see. Yes, that's right. But that was just a conventional same employer, different types of establishment situation. And not difficult at all to say it's single source. It's the same employer is the paradigm of a single source. So that doesn't really advance the argument, does it? Or have I misunderstood?
What we say is that when you look at our facts from say a single source perspective, the respondent had the power. Excuse me.
Right.
The respondent had the power both to create and then create the inequality and then to restore equality.
Yes, I see. So
They're all in the same park. So even if they're different from Asda, in that they're not the employer, they're all on the same.
but if that's taken too far, Allenby should have gone the other way because they were all in the same college. The money ultimately is coming from the college. In some cases direct, in some cases by paying the contractor. But in Allenby that was held not to be enough.
I just wonder, I mean, you're looking at section 41, which clearly has a tripartite situation in mind. So we're not looking at the Asda case, i.e. the principal, the contractor and the contract worker. So we're not looking at an Asda type situation where it's one employer and the employees at different sites, warehouses and supermarkets. That's not what we're dealing with. It's unhelpful, isn't it, to look at the use of single source in EU law where we may have to interpret an act were we still to be members of the European Union in line with European law. We really are just deciding whether the unique, as you say, or near unique facts in this case, where the price is dictated by the respondent and is directly translated into the salary, can be put into the words, allows them to work on those terms. Normally it covers canteens and things, but you say this is an unusual case, and I wonder whether single source doesn't muddy the waters or the pool in the park, rather than clarify.
Well, I accept your point. My intention was to basically put the weight of the argument on when Allenby in section 41 and the single source is.
I understand that. The truth is, the kind of arguments that you would deploy under single source are effectively just the kind of arguments you're deploying in your primary argument, and
Dressed up a different way.
dressed up a different way. Yeah. Okay, thank you.
Well, before I move on to point number 2, which regards the formulation of the PCP, is there anything else I can assist the court with on section 41?
Not as far as I'm concerned, you've been very helpful so far.
Well, I'm grateful. So turning then to the PCP, what was pleaded?
Is this ground one?
Yes, my lord, yes. It was ground 1 of our notice of appeal.
So it's PCP pleading.
Yes. I believe it also links in with additional reason 3 in the respondent's notice. So. And my lords, on an appeal, I wouldn't usually take up the tribunal's time with explaining how arguments were put and evolved. But I think in this case, I need to, if you may indulge me,
Don't apologise. If you think you've got to do it, do it.
Thank you. I think this, your lordships would benefit from knowing how the arguments were put on each side, both at the outset of the case and then what happened on the final day of the four-day hearing, and then how this produced the ET's judgment. And in doing so, I hope to address the points made by Mrs. Justice Eady in the EAT's judgment. What I say, the claimants put their case in their ET1. They put a positive case, which was based on what they knew. Obviously, they couldn't plead facts which are beyond their knowledge.
Well, I mean, to some extent they did, because they pleaded that there was a policy of paying the London living wage to their direct employees and not funding the payment of the London living wage to outsourced employees.
Well,
And unless you're trying to say otherwise, para 12A doesn't say anything specifically about employers on the toilet and cleaning contract, workers. It is in general terms. So in that sense, you did plead something you didn't know. And that's not a criticism, because there are plenty of ways available to you in the case, even if you hadn't taken advantage of the pre-issue procedures, of finding out what the position was for outsourced workers generally. So I'm not saying it was an improper pleading at all, it's very clear pleading. But to say you pleaded a positive case based on what they knew isn't quite right, is it?
so my lords, if I could refer you to the pleading then.
Yes.
So core bundle tab 10. And this page, I apologise that there are multiple page references in the bottom of each page.
That doesn't matter.
It's page 139, which is
Yeah.
that bottom centre reference.
You have to start at 137, I think, because you have to start at the introduction.
Yeah.
Person concerned would think, firstly, what is this all about?
Yes. So
You get that from paragraph 2, don't you?
yes. So paragraphs 1, 2, 3, we intended to plead as an overview or an introduction to ease the reader in.
Yeah. And the focus is the way that direct versus outsourced workers are dealt with.
Yes.
And outsourced workers are treated less favourably than the direct employees. And most of the outsourced workers are from a black or minority ethnic background.
Yeah.
And lo and behold, and they're more likely to find themselves in outsourced roles, plural.
Yes.
And then lo and behold, these claimants are in precisely that position.
My lord, yes. Paragraph 2 was written with the intention of summarising the argument which follows. So it's an introductory. This is what's going to come in the pleading itself. Paragraphs 4 and following under the subheading facts explain the facts and the dates, which is paragraph 9, on which various decisions were made. Paragraph 9 talks about the period November 2014 to the 11th of December 2019, which is the period concerning the cleaning contract. Once that scene is set, we have over the page the new subheading claims. And the italicised heading Section 19 Quality Act PCPs 12A leads the PCP, and it's the opening rider up until 11th December 2019, which is a renvoi, so a reference back to paragraph 9, the end of the period in which decisions made in the cleaning contract.
It's paragraph 10, isn't it, really?
Yeah, sorry, you're right. Paragraph 10, the 12th of December is the date in which the respondent, we say, stop supplying the PCPs.
May I just divert for a second, or it may actually be relevant to this. The phrase following strike action, I couldn't find any reference in the ET to any strike action.
Right.
Was there evidence about strike action? If so, who took it?
It was strike action by the UVW, which successfully resulted in the decision to adopt the LLW.
Am I right that there's no findings of fact about that in the yeah, I may just have missed them. I probably didn't read it carefully enough.
He certainly doesn't major on them, my lord. No, so I think the close. You're right. It doesn't. For page 118, paragraph 53 starts with on the timeline of the 6th of November 2019. Then paragraph 54 moves to like the day after the decision to award LLW, which is the 13th of December.
Sorry, which paragraph are you looking at?
Paragraphs 53 and 54. And the strike action comes chronologically in between those two paragraphs, and it's not mentioned.
Well, I had actually read somewhere it wasn't just UVW pressing for this. Was it? If you look at the pay claim, if you look at para 46,
Yes.
PCS and Prospect were pressing. Is this right? PCS and Prospect represented and were recognised for the direct employees.
Yeah.
But they also had members among and were anxious for the interests of the outsourced workers. So quite regularly in the history set out here, PCS and Prospect were asking Royal Parks to make it a term of their outsourcing contracts that the London Living Wage were paid to outsourced employees, square brackets, most of whom were PCS Prospect members, and we're getting the formally correct answer that falls outside the scope of the pay negotiations because you're not recognised for those people because we don't employ those people. Nevertheless, they kept on asking for it, and their pressure was clearly an important part of what changed the position, or apparently. UVW, is this right, don't have, or there's no evidence they have significant membership apart from in the toilet and cleaning workforce.
My lord, you're right. Outside of the toilet cleaning contract,
Yes.
UVW had no membership.
And again, all this may not matter, but at some point we're going to have to sort of tell the story in our judgment and see exactly how it came about. Just reading the ET decision, I don't get the impression this was in response specifically to UVW pressure. It was to pressure from the unions generally, of which they were one and actually quite a small part because their workforce is quite a small part. And there is no mention of any industrial action or any strike. There's a reference of threatened industrial action somewhere.
In the submission to the board.
I thought no, in somewhere in the findings, but I may have got that wrong.
The impression I get from the paragraph 50 and 51 is that they were discussing, the Parks people were discussing this generally, and then at 51, I thought that they agreed that all contracted workers would eventually get LLW once the contracts came to be renewed. And it's seen from 52 onwards that what happened with the Parks one is that there was a notice to extend the contract.
101 and 117. The references to strike action in the ET decision are bottom of 101, which is simply a recycle from the document which we've been looking at a moment ago.
Yes.
And 117, which is a quote from the paper of Miss Wadd presented to the board.
That's very helpful, and that's indeed what I think that's what I was saying, the potential for strike action.
I think it's also
And it doesn't
paragraph
appear to be
45.
specifically strike action by UVW. It may well have been. It just doesn't say.
So paragraph 45, grateful to my lord for pointing out the other references. Page 116 at the end of 45. There's a reference to.
That's
effect.
right. They threatened industrial action. Thank you. Yes. Okay.
Then what actually happened is paragraph 51, they did decide to give the LLW eventually to every outsourced worker once the contract came up. And then for reasons that became 52 and onwards, there was a change control notice, whatever that was. And it seems to be connected with that the toilet staff got the LLW. I don't know at what date, for example, whether every outsourced worker on or about the 13th of December also got it, or we just don't know. So I don't know if I can be sure that the reference in paragraph 10, following strike action on the 12th of December, the respondent made an executive decision to increase outsourced workers' rates of pay to bring in line with the LLW. Whether that's all outsourced workers, whether it's a reference to the general decision, or what, it's very difficult when you say that's the intention. If I'm reading words, I don't know that I know that.
My lord, yes, I appreciate it. It's one of the challenges for any appeal panel to try and consider what known at particular points in time. Paragraph 50 of the reasons, which is page 117, quotes from the board. That was one of the documents disclosed for the first time during the 4-day hearing.
Well,
And there's a reference to that in my closing submission.
yes, I think it's my fault, but I don't regret it. I distracted you by just finding out what this reference to strike action was meant to follow up, and that's got us into more general territory.
Right.
Why don't we come back onto your obviously carefully planned course? You were showing us the pleading,
Yes.
and you were. I think your point can really be summarised as although the literal language of 12A and indeed of 2 refers to outsourced workers generally, the only specific facts pleaded relate to UVW, and that reflects the fact, as you're going to come on to demonstrate, that UVW didn't really know what the position was about other outsourced workers, even though they had pleaded it in general terms. Is that a fair summary?
Yes, my lord, it is. And if there's to be any criticism of the pleading, I have to hold my hand up and take responsibility. This was my pleading.
About that. It's
What I say, 12A of the grounds of complaint is that it's the opening words which set the time frame up until the 11th of December 19, which the claimants understood was the night before the PCP ceased to be applied, so far as their frame of reference is concerned. They were denied LLW up until the 12th of December, when things, well, they will change.
But in fact, they then got it back retrospectively for
Yes.
6 weeks. Yeah.
Yeah. So I would ask you to read the grounds of complaint through the eyes of the claimants at the time.
Ooh, that's dangerous. I mean, formally, we must look at it from the point of view of the objective reader.
Yes.
And you, I think, are entitled to say that includes, and in particular, the respondents need to know what case they're meeting. If the respondents knew things about what you knew, that might affect how they would naturally read it. But I don't think it's right to look at it from just what's in your mind.
Right. That's a very fair point. What I say is that they have to be read at the time, as of the time they're written. So at the time that the ET1 is filed, the claimant's knowledge extends no further than.
Well, would the respondents know what your knowledge it's consisted of. Clearly, although you weren't recognised, you were clearly making representations as part of the same pay round. We can see that from the sequence of events. I don't know, and there are no findings about the extent to which information was shared between UVW and the other unions, or individual employees knew what was happening to members of other unions. We just don't know, but it wouldn't, Respondent might well think that the unions pretty well knew what each other were doing and what each other's position was, especially as it was roughly the same.
But also to address your question, what did the respondents, how did they read the pleading, and what?
Yes, well, that is interesting.
Could I have one moment to find a reference? So, my lords, in the supplemental bundle, at page 23, paragraph 12. This is part of what were my closing submissions before the ET.
Page 23 of the supplemental bundle.
Yes, please.
Thank you.
Sorry, I'm behind. Supplementary bundle, page 24.
23, please.
Sorry, page
23.
23. Yeah, thank you. Yes.
So paragraph 12. Where I addressed the ET on the very point this court has just raised, which is what did the respondent understand by the claimant's claim
This is your document to the EAT, is it?
to the ET?
Yes.
To the
First
ET.
instance, yes.
Sorry, okay.
I don't mind you taking this to us, but I thought what you were logically taking us to next is what the grounds of resistance said, but
Yes. So sorry, this was my. I should just take you straight to the document, shouldn't I? So
Before we go to the grounds, I just wonder whether we're picking paragraphs at random, and I did have a point about paragraph 13, which you may want to pick up before you go to the grounds of resistance.
yes,
Because when you get to the pool, the normal understanding is the pool is all people to whom the PCP applies.
yes,
So if the pool is expressed in one way,
Yeah.
that might well help you know what the PCP is defined as. And the pool is actually, the pool for comparison consists of all the respondents directly and indirectly employed staff. So that suggests that the PCP was a PCP which differentiated between all the respondents directly and indirectly employed staff, not just the Vinci cleaning contract staff. And I know you say it should now be read as indirectly employed staff to whom the PCP are applied, but that begs the question at this stage, you're trying to work out, well, what is the PCP? And if the pool is all indirectly employed staff, doesn't that mean the PCP is all indirectly employed staff? And isn't that the reality? Everybody knew the outsourced workers weren't being paid LLW because the Royal Parks weren't prepared to pay LLW.
So the respondent knows the position with respect to all outsourced workers. The claimants, and this is how they bring their case, knew only the position.
well, you keep saying that, and I don't for a moment. It was a bad start. You keep saying that, but there are no findings about what UVW knew about Royal Parks' policy generally. I don't know for how long UVW had been represented with a small r. a proportion of the toilet and cleaning contractors. But one might have expected that if they were, and were clearly in a position where they were writing to and had correspondence with the Royal Parks about their members, that they would actually have quite a good understanding of the Royal Parks policy towards the London living wage generally. There's no doubt it was a general policy. It'd be a bit surprising if they weren't aware that that was so. Now, there don't appear to be any explicit findings about this, maybe because that isn't how the case was focused, but I'm not prepared, with respect, I don't mean to say anything rude about you, but I'm not prepared just to take it from you that UVW didn't know that there was a general policy of not paying the London living wage. I'd have thought the likelihood is they did know that.
My lord, I can only speculate one way or the other.
No, but
What I can say for certain is that they had no window into the bidding process and the degree to which, if any, the Royal Parks were involved in setting the pay with.
certainly back in 2014, but that's a slightly different point. That's a point that really goes to the Section 41 issue. Now we're on a question about what their practice was about requiring contractors to pay the London living wage. And if, for example, UVW knew that the gardeners weren't getting the London living wage, the catering workers weren't getting London living wage, and so on, then they would know there was a general practice of not requiring contractors to pay the London living wage, because if they did require them to, they would get it.
Lord, I'd put it differently. The policy here is the Royal Parks stipulating as part of the tender process what the minimum hourly rate should be for outsourced workers. The UVW had no knowledge of what involvement the Royal Parks had in other bid processes for other outsourced workers. When you talk about whether they applied the policy, we simply don't know.
But sorry, that is a slightly different point, isn't it? Or maybe it isn't. You say it comes under the heading of applying the PCP.
Yes.
There might be some outsourced workers for whom the terms are not fixed by the parks, as they were, you say, in your case. So there might be a subset of contract workers who aren't within Section 41, which is a separate point. But standing back from this, it's a charity. There are references littered throughout the Employment Tribunal decision to board meetings and papers to the board and the board decisions. I don't know whether the board minutes in the board papers were publicly available, but at 42 and 43, they're asking for advice about the impact of introducing London living wage for all contractors and concessionaires, and then there's a paper about that on the 8th of November, and the decision is finally taken in respect of all contractors, although the time will change. And I'm finding it difficult to believe that the unions didn't know that across the board, with arguments at the margins, that the starting point was London living wage, or believe the starting point was London living wage for direct employed staff, no guarantee for London living wage for outsourced staff. And if that's what the position was, the pleadings make very good sense, because they're saying that's not fair. You can't treat the outside as different from the inside.
My lord, the issue the claimants had is that they learn about these documents, and again, that's why I was trying to take you to my trial submissions.
But if they're publicly
Disclosed.
available, how do we know that they didn't learn about them? I don't even know if the board minutes were or were not publicly available. And I don't have witness statements saying, well, they may have been publicly available, but none of the people in the union and none of the claimants ever read them.
See, sorry, I haven't given you a chance to answer my lord's point, but perhaps you can
Okay.
It may be to some extent superseded. If you look at 48, page 116, sorry, 48 of the ET decision on page 116.
Yes.
It looks, well, firstly, just going back a couple of paragraphs, the first real mention we get of UVW is at para 45. And I get the impression, I don't think there's an explicit finding to this effect, that UVW had really only recently started to recruit members, and this was their first approach to Royal Parks in the summer of 2019, saying, can we now please be recognised? Reference to Vinci on 27th of June. So that they looked as though that they were new kids on the block in mid-2019. I don't know whether that helps you or not. And then they are dealing with Vinci, and they have a meeting with Mr. Jarvis of Vinci. And he says at the bottom, page 40, paragraph 48, although the payment of London living wage is not currently a mandatory requirement on Royal Parks contracts, Mr. Jarvis is
UVW.
no, Mr. Jarvis is from Vinci.
No, Mr.
I
Jarvis.
certainly read that when I first read it, perhaps you may say wrongly, as being that Mr. Jarvis.
Jarvis is the director of parks for the respondent.
My lord, you have his written statement at the end of the
Yeah,
supplemental
exactly.
one. He's the superintendent of parks.
Yes, he's the principal person.
Yes, I see.
Somewhere.
Yes, thank you. But right, so what you get though is I read it right first time. I just confused myself. Mr. Jarvis for Royal Parks, corresponding directly with UVW, about whom he's obviously learnt from Vinci, sets out what the Royal Parks policy is. And it's not just about toilet and cleaning contracts. It's not currently a mandatory requirement of Royal Parks contracts.
My lord, I would read this a different way. What he's saying is giving a diplomatic response to UVW, which leaves unclear whether they also, whenever they received a LLW costed bid and a NMW costed bid on other contracts, whether their policy was always to opt against
No,
LLW.
I see that. It doesn't say that. You're quite right. But does that actually matter? They have told UVW for our outsourced contracts generally, we do not require payment of the London living wage. And it's a reasonable inference from that therefore most contractors don't pay the London living wage and price on that basis.
And as I say, not necessarily.
Well, it's not inevitable, but I think it's a common sense implication.
Because what matters to the Royal Parks is whether the one from the outside you assume is whether the overall price is right for the contract. So you could read that as saying, well, we don't get into the nuts and bolts of what
Yes.
hourly rates are. We don't impose a mandatory London living wage standard.
Well, I agree, that is what it's saying, but isn't that important from the point of view of how you formulated your case and how your case would have been understood by Royal Parks? Royal Parks will have known that you knew, as you've been told, that this is our policy generally. Not, I appreciate the particular point about making a choice between two prices, but generally we do not require our contractors to pay the London living wage. I'm sorry, I know my lord wanted to make a.
No, I was just wondering whether this, I mean, I speak for myself, I find this a very sterile area of the case, and I know you have to deal with it, but only in order to get across it to argue your main point. I wonder, could we see the passages that you were going to take us to, which you quoted at paragraph 12 of your document, the grounds of resistance and the an email.
Well, my lord's anticipated what I was here to say, I think. But I think it's been helpful, but I think we need to move on to actually what you pleaded, how they pleaded in response, and then how the submissions developed. Can we just see how they pleaded in response?
Yes, and then I will go into the email, my lord.
Yeah.
So what they pleaded in response is core bundle tab 12, page 186.
What, 186? you say?
Yes, please. So towards the bottom of 186 under the subheading PCP, firstly they're quite blunt and say you haven't identified any PCP which applied by us to the claimants.
Chagos,
Yes.
I'm so sorry, but if we're going to do this, I wonder if we could start earlier in the document.
Wait,
Paragraphs 10 to 12.
Well, I've gone on reading.
okay. My lord and friends asked me to take to paragraphs 10 to 12. I don't object to it, so I'm happy for you to look at page 179.
Yeah.
Paragraphs 10 to 12 set the scene about what the respondents' predecessors did.
Yes.
And then when you move on from that background and to the specific response to the claim, at page 186, focusing on the PCP, paragraph 44, they say the claimants haven't identified a PCP, which was applied by the respondent to them. Paragraph 45 is pure argument, put it that way. They say there is no unified PCP of this nature at all. So there they are.
Yes, but we're looking at how they understood your claim. If you look at the middle of 47, the claim is the respondent adopted a double standard, because they adopted a different minimum depending on whether staff are employees or outsourced workers. So they seem to have understood it as being a general, unsurprisingly, because that's what you said.
They then go on to say it's to do with the Vinci, or the award of the Vinci contract, on terms on which that contract was awarded.
They're trying to say they don't have a PCP at all. You are saying, yes, they do. But really, the question is what PCP you were pleading. They've got the Mandy Rice Davis. He would say that, wouldn't he?
Yes.
Defence. And the real question is, what are you doing? Even leaving aside the words on the page, the reality is that there are two groups of workers in play here, those who are directly employed and those who are contract workers. It may be that some of the contract workers fall out of the equation for quite different reasons to do with the word allowed and the extent of the involvement. But standing back from it, there are two broad groups of people in play here, the direct staff and the contracted staff.
Yes.
And reading the pleading, the question is, were you going for all direct staff, all contract staff, or not? And it would be illogical to go for part of the contract staff if you don't know that they're not outside because they fall foul of section 41. The comparison is going to be flawed unless you include potentially all the contract workers, because otherwise you're only having part of the comparison.
Well,
That is the point they make at para 49.
Oh, good.
I mean, you wouldn't mind me rewinding back to paragraph 46,
Yes.
because the respondents, on the one hand, they say, and this is the third line in, it does not apply any pay stroke benefit rule to staff it does not employ. And then, so what on the one hand, they're saying we don't apply any PCP to it, anyone other than our own employees. And then at paragraph 48, they then posit two other pools. Sorry, I beg your pardon.
But I mean, basically, your argument on this hinges on the words "wrong pool," doesn't it? That they're very slighting about your pleading of this. Firstly, you haven't got a PCP at all, and secondly, you're aiming at the wrong pool, at least on one view. I mean, isn't that what this shows?
Yes, but then they don't say what the right pool is.
No, but I mean, all you need this for, so it seems to me, is to take you on to your main argument, which is, were you entitled to plead the small pool?
Just to spell it out, there are really two points. One, did you plead the small pool, despite the literal language of 12A, which appears to have pleaded the wide pool? And the EAT put you down on that. They said you did plead the wide pool, and then you didn't prove your case under it, because you only tried to prove your case by reference to the smaller pool. As my lord says, ultimately, the real question, or the more substantive question, once we get behind the pleading point, is what should you have pleaded? You haven't got to that yet, but you're going to.
What would the PCP be if you were saying you're trying to compare direct staff with Vinci people alone? You've got to identify a PCP that applies there.
So we not knowing what how the Royal Parks dealt with other contracts and their involvement in other contracts, it would have been impossible for us to rule in other contractors as people who were subjected to the PCP that we were.
Because of Section 41 or for other reasons?
Yes, because we don't know whether all of those other contractors are paid the London living wage or paid something less, and if they aren't, we don't know how it's come to be that they are
Isn't
paid
that a
to
classic situation for a questionnaire? Certainly under the Equal Pay Act, but I think also under the Equality Act generally, there's provision for questionnaires, pre-hearing, pre-application, pre-claim questionnaires. Maybe that's only under the Equal Pay provision. My lord remembers that.
I thought it was under the SDA as well, and I assumed it went into the Equal Pay
Yes,
Act.
I think it.
Into the
Unless we hear to the contrary, we believe there is a questionnaire procedure in which you can ask precisely these questions, because recognizing, as the legislature did, you have a hunch, you have grounds for believing there's a problem here, but you don't know the facts, and then you use the questionnaire procedure. If you don't, you can always start proceedings, a little bit hairy, but you can start proceedings pleading what you hope you may be able to prove, and then quickly get into disclosure to make sure you can prove what you hope to be able to prove. But just to be told we didn't know how Royal Parks dealt with employees isn't a complete, with outsourced employees generally, isn't a complete answer. And that's, of course, a point that Mrs. Justice Eadie makes.
Could I take you to the
I tell you what, Mr. Khan, I think it's our fault. You've got a very clear way through this. We haven't been able to resist asking questions, and it's been a helpful process, I think, for all three of us. But I think let's just follow through your exercise. We now see what they pleaded in the grounds of resistance, and now you want to get to how the case was put at the hearing. And I think you were taking us actually to what you put in your closing submissions.
That's right.
Had the point emerged earlier than the closing submissions? Case management conference, opening submissions, or did it really only emerge in your closing submissions, you're saying?
So at the, if I could take you to the timeline. So the case was heard for 4 days, starting on a Thursday. So we had days 1 and 2 before the weekend, and 3 and 4 after the weekend.
Yes.
But on the Friday, shortly before the weekend, we received an email from the respondent solicitor, which I've extracted. So supplemental bundle, page 23.
Say the number again, please.
23, please.
Yes, I see.
And it's the bottom subparagraph there, 12.2. So the respondent's solicitor emailed us on Friday afternoon, said, here are some additional documents. And then they also said, additional documents are now being collated. These are not obviously relevant to this case, as they relate to LLW in respect of individuals working on other contracts, for example, landscape maintenance. So on the one hand, they're saying, well, we don't think those other contracts are documents because they're are relevant documents. And presumably that's because they don't say that the other contracts are relevant. Then they explain why they say they're not relevant. And then they explain their understanding of the claimant's case, which is they relate to their roles and the respondent's own employees. And so they send, if you like, a bit of a teaser. Here are some documents, we're collating some more. And then whatever additional documents they were collating, which they promised, were never in fact disclosed.
So when did that come in? When you say the start of the last weekend, you said you were on Thursday and Friday and Monday and Tuesday.
Yes.
This is your closing submissions, is it? So was the weekend in the middle of the hearing?
Yes, so we had days 1 and...
Not before the hearing, but in the middle of the hearing.
Yes, so we started on a Thursday. And just so I'm absolutely certain. Yes, you'll see from the ET's reasons that the hearing dates are the 19th, 20th,
Yeah.
then 23rd and 24th. Weekend. I decided the weekend.
And just so we can get the sequence right, were closing submissions on day 4?
Yeah. In fact, there might even be a date at the end of. Yeah. So the
24th.
24th.
Is that date? What? Sorry, I just haven't picked up the dates.
Yes, that's day 4.
That's day 4. So you basically sat up late on the night of day 3, the Monday night,
Trying to.
and produced this. Okay.
We've all been there.
Yes, certainly. I remember it well.
So what I say is that the respondent here is like dangling a slither of discovery about other documents, and on the one hand saying, well, they're not relevant, but here they are anyway, and there's more to come. And then in closing, springs a point and says, well, other contracts are certainly relevant, and other contractors must be in the pool. We haven't disclosed what those contracts are, but because the evidence is missing, the claim must fail because you can't make out group disadvantage.
Well, standing back from it logically, unless you can find a reason to subtract some people from the group of contracted workers for comparison because of Section 41 reasons, unless you compare...
Section 23.
Well, Section 41, I was thinking the fall outside
Sorry.
the scope of it, actually. But logically, standing back from that, unless you can produce some reason why some of the contracted workers should be taken out of the group, the thrust of the claim is you're paying your internal people this amount, you're not paying it to us. And that's not right and fair, contrary to the Equality Act. So I don't see how you could have drafted a PCP logically, which didn't include at least the possibility that there were other outsourced workers in the same position as you who had to be included for the purposes of comparison.
So,
It might be all of them, or it might not be one particular contract.
so the positive case we pleaded related to the contract, the only contract we knew about. We didn't try to exclude or shut out in our pleading the possibility there might be others, but no evidence having been produced that others also have the PCP applied to them. How
Well-
could we rule them into the pool?
Sorry, and it's you, and I'm not criticising, it's you who's wanted to take us down this path of how it all emerged.
Yeah.
And you jumped straight to effectively halfway through the hearing.
Yeah.
But it's clear from para 12, sorry, not from para 12, but from para 9 on page 22. That this point had blown up at some point earlier, and that's why you were dealing with it and making the points you're now making. So now, from discussions in the tribunal, it appears the respondent is misconstruing the grounds of complaint.
Yes.
And we know this anyway because the ET deals with it at the very beginning of its reasons. So I just want to understand how this all went. We're getting a slightly
So from
district.
I can't remember whether
Were there written opening submissions?
there was only from the claimant side. There was I think I did like a brief 1.5 page written opening. I can try and find that. Not in any of your bundles.
Is part of your case, I don't mean to jump in if there's a thread being followed here, is part of your case that also it's important what the ET understood your case to be. They deal with this between paragraphs 2 and 5. Before they even get started on the issues. This is in
101.
page 101 and 102. And I appreciate you have to deal with this because of the EAT taking a different view, but we'll have to consider whether this was a question of law or whether basically this was a matter of procedure and that a specialist tribunal is to be trusted to know what the parties are actually about. And this is what the specialist tribunal thought the parties were actually about.
Yes.
And that it could only really be gainsaid if as a matter of law they weren't right to do that.
My lord, yes.
What if all the other contracts
Sorry.
have people where the overwhelming majority of people on the gates and so on are white? When you add up all the outsourced workers, if in fact they all don't get their LW and the process was the same, parks weren't prepared to pay at that stage a contract price which included LLW, you wouldn't know whether there was indirect discrimination, whether it put people with the protected characteristic of ethnicity.
That's the next stage of the argument, isn't it?
It is the next
the next
stage.
stage
You
of the
can't
argument.
know whether what you're comparing in numerical
No,
terms.
sorry, well, I think help me. I absolutely take my lord's point of view. Help me just to get to the end of this section, which I think we've almost done. What you have demonstrated, well, what is clear is that if you literally read paras 12a and indeed 2, you are defining your PCP in terms of the entire outsourced workforce. You say, if you read the pleading as a whole, that's not a fair reading.
But also I say
And
12A has
and then you also say it is reasonably apparent, not so much from the grounds of resistance, which was slightly argued in a different direction, but certainly clear from the correspondence you received in the middle of the hearing, that the respondents understood perfectly well what your case was, and that therefore the Employment Tribunal was entitled to proceed as a matter of pleading, as a matter of what case you were advancing, on the basis of the narrower pool. We'll then, in a moment, come to the question of if they were entitled to do that, was that the right pool, which is what my lord has been leading on to. But as my lord of my right says, we have to go through this first thing, dry though it may seem, because it is actually the basis on which you went down in the EAT.
Yes.
And have we got all your points on that now? One reads the ET as a whole, the ET1 as a whole, not just para 12A in isolation. And two, the respondents weren't misled. Look at what they said in their own correspondence.
My lord, yes. The only
What do you want to add anything to that?
small point I'd add on paragraph 12A of the pleading, and forgive me for repeating myself, is that it opens with the dates
Up until the 10th of, yes.
Yep. And I say that's a renvoi back to the facts regarding the cleaning contract.
Okay.
But-
So we made it difficult for you by straining to get on to the underlying point, but on the pleading point, that's all you have to say. Is that right?
Yes, I think I also owe you an answer to your question, which is how did the point arise?
Oh yes, thank you.
Because
That would be
said,
helpful. Yes.
doing the best I can from memory, we finished the evidence in good time, and although closing was on day 4, the respondent's counsel, who was different
Not
from
Mr.
my other
Milford.
friend, was Mr. O'Dempsey.
Yes.
Whether it was him or whether it was the tribunal, I can't remember which, but the issue was raised after the close of evidence about, what submissions, what form they'd take, and I can't recall one way or the other whether it was Mr. O'Dempsey for the respondent who said
Yes, I see.
we're going to be making this point, or whether the tribunal raised the point. I can't recall which way round it was. But
So-
that's the reference to in discussions before.
Yes,
the
I see.
tribunal.
So at some point on day 3,
So after the evidence.
after the evidence, but before closing submissions,
Yes.
a question arose about how the PCP was defined. I.e. narrow or broad. That's a sufficient. Yeah.
I think the other point which I don't want to leave without addressing is regarding the statutory questionnaires.
Yes, thank you.
I'm grateful to the team behind me, but I will have to double check the point myself. What I understand is that for acts of discrimination on or after the 6th of April 2014, the statutory questionnaire process has been abolished.
But just hold on. Right, well, that's very interesting. So the answer to the statutory questionnaires, not relevant. So insofar as there's a point against you, which the EAT did take, they must have been had in mind either informal questions beforehand or exploring it as part of the ordinary forensic process once you'd started the case, i.e. asking for disclosure and so forth.
Yes. Although
I mean, there's no doubt that if you had, which you weren't, but if you had been wanting to advance the wider pool, the first thing you would probably want to do was to say how many outsourced workers are there, what are they paid, what do the contracts say, and what's their ethnic breakdown.
Yes.
Yeah, but those steps weren't taken because you in your own mind were focusing purely on your own pool.
Yes.
Yeah.
And if we were to engage the respondent on some other pool, which they still hadn't clearly put forward a positive case on, even by day 3, I suppose what you realistically we'd have to do would be to call for an adjournment and say there needs to be a
Well,
clearly pleaded positive case by the respondent, and following that, disclosure.
But for good reason or bad, it may well have been for good reason, that course was never taken. You say because the dispute didn't mature until closing submissions. Yeah. Okay, I think we've now done the pleading point to death. And can we get back onto the substantive point,
Yes.
which is essentially, if you were to be understood as having pleaded only the narrow pool, was that a proper pool? Because of how the PCP extended, because what the argument against you is not a proper pool, because the PCP was not confined only to the toilet and cleaning workers.
Yes, but that argument rests on the assumption that in other contracts, the Royal Parks had a similar level of close control over the hourly rate term. Because if that argument is right, then the Royal Parks, there was focused hovering, to use my lord's phrase, in those other instances as well. But we have no evidence of that.
The problem is that that's half the equation. If they were not controlled, so they weren't to be treated as Section 41, they fall out of the other equation as well, because you say they're not people who go into the other side of the balance, into the kind of people that are getting the LLW. You say you don't look at the direct workers and all the contracted workers who do get the London living wage, because unless they get the London living wage, because the parks have said they must get the London living wage, they aren't taken into account. So you say it's a necessary factor, whichever side of the equation you're looking at.
Oh, yes.
That you need to know whether they've dictated the London living wage outcome.
Yes, and that's both the, my lords have discussed, it's both the Section 41 issue and the Section 23 material circumstances issue.
Yeah.
Hang on one second. So it's not enough, you say, that you knew, as I think the evidence, and evidence you will always have had, because it's a letter to you, shows that there was a policy of not insisting. There were these other. The pool will only extend more widely if all the other contractors were effectively treated in the same way as Vinci.
And told to pay the London living wage.
Yes.
Told not to pay.
Oh, paid not to pay, sorry. Yes.
Well, given the option.
If it was left to them and they could or they couldn't, and it's their choice, then they wouldn't be in the same position as your lot.
And we also don't know, on a more basic level, whether the other contractors were paid the London living wage. From Mr. Jarvis's his position expressed in his letter, he leaves open the possibility that some, but not all, of the contractors, other contractors, are paid the London living wage.
Or because it comes up on retender.
And also because he says we don't insist upon it as a mandatory requirement, and then on the other hand says, but it's an aspiration. So it could have been that.
Yeah, but the aspiration is clearly a Royal Parks aspiration, so it's a Royal Parks aspiration to make it mandatory.
I could go back to the reason, so page 116. Yes. But I say the wording there is sufficiently flexible that it doesn't actually tell us whether factually they. All it says is that they don't insist upon the LLW. It doesn't say that we reject LLW bids. It leaves that open to interpretation.
I had the impression, unless you try and show you to the contrary, that it's pretty clear that none of the other contractors paid the London living wage.
May have done by chance to some managers and people who just simply had to earn more, but the London living wage was not taken as the minimum.
Implicit in paragraph 41, but you would say it doesn't go far enough, I imagine, because that still leaves open the choice. Everyone's assuming that unless the Royal Parks okay a contract price for the overall contract, which is built in as one element, the London living wage, then it's not going to be paid. And you're saying you can't assume that that will legally be the position for the other contracts.
We just don't know the commercial
That is the
terms.
real world, isn't it? And is implicit in all the discussions about this, that unless you make it a mandatory requirement, it won't be paid, because people are, maybe they shouldn't be, but people are prepared to work in London in low-paid manual jobs at below the London living wage, so that Vinci and other contractors can get people at below the London living wage. If you're going to have the London living wage, it can only be because they are required by their principals to pay more. I mean, to pay it.
Even the phrase mandatory requirement, it involves forgive the expression, a bit of spin, because in the Vinci case, you have the contractor who wanted to pay London living wage, wasn't being required to.
I'm sorry, that there's nothing to that effect, that the contractor wanted to pay the
Well,
London living wage. No?
The contractor put forward two bids, one on the LLW and one on the national minimum wage. So the indication being that it was quite open to paying the London living wage.
Yeah, well, yeah, I think
If the parks would pay the cost.
Yes. So the ball was in the parks.
Yes, no, well, we've been into all that on section 41, but what we're on now, I think, is the question of whether there is evidence, or it can properly be inferred from the facts which the tribunal has found, that the pool was in fact wider. That is to say, that none of the other contractors paid the London living wage. We know they weren't required to. You, I think, say the two things we don't know. One is whether they nevertheless did. And secondly, whether they were offered an explicit, whether any of them had offered the explicit choice to Royal Parks that was offered to Vinci. And it's true, we don't, I think, know either of those things. For reasons I put to you, it's pretty likely that the London living wage wasn't paid to any of the contractors, as we know they weren't required to. So it wasn't paid by any of the contractors, because we know they weren't required to. I agree, it is less obvious that any of them, assuming that none of them were Vinci, offered an option at the time that they tendered for the contract. I'm wondering whether that's decisive.
But we also don't know whether the Royal Parks other contracts included a clause similar to what was, I think.
What we do know, and we referred to this earlier on, was that by the end of 2019, LLW for your group would cost £225,000 a year, and LLW for the entire outsourced workforce would be 1.2 million a year. And so there are certain inferences that could be drawn from that. In other words, that there were a lot of people who were not on the London living wage in outsourced work,
Yes.
and not just these claimants.
Yes.
That is
The implication, that is the implication from the evidence. The key thing that you say is there are two separate things. One, were they getting it? But the second thing that you say is some people wouldn't have been within the pool because they weren't within section 41 and they weren't people to whom the parks applied the requirement. That's your real point, I think.
Oh, yes. Were they getting it? And if not, why not? Was it because of the parks direction?
Because if it had nothing to do with the parks, he wouldn't put it in the pool.
Yeah.
The problem you've got is the pleading is dropped. That's why I think they go together. You wouldn't have pleaded something unless it was logical. And the logical position is nobody seems to be getting it. Why not? Because there is this policy, the double standard, as it's called in the pleadings, of paying one thing for your own and less to outsiders, and not insisting that outsiders get the same. Leaving aside all the detail. Anyway, we've been over that.
Otherwise, I don't know whether I could take you briefly to Tom Jarvis's witness statement. He was the only witness called.
Yes, this is before the tribunal.
Yes.
We tend to be a bit cautious about looking at witness statements unless we also know about cross-examination, but that's not
So
inflexible. Was Mr. Jarvis cross-examined on this?
he was, my lord. What I wanted, before I delve in, then perhaps I can tell you the point,
Yeah.
announce the point, and you can tell me whether this is fair game or not.
Well, I don't want to exclude it. I just want to be careful. Yeah,
Yes.
but what is the point?
Tom Jarvis's witness statement gives no direct evidence of how other contracts were negotiated and whether there was, if you like, two bids or whether there was direction by the Royal Parks to the contractor to pay less than the London living wage on the other contracts. And I can make that point, but I don't know if you would prefer me to briefly take you through the parts, or whether it's something you prefer to read in your own time without me.
Well, I think personally, for myself, if you say, and I'm sure you wouldn't say that, having rejected, Mr. Jarvis gives no evidence about this point, I will take that from you, and if Mr. Milford says, no, you overlook what he says in paragraph something or other, then he can say that and you can do it in reply. I don't think you need to take us through it to prove a negative.
Great. Well, I think I have to, unless you say otherwise, my lords, I have to address the question whether it was logical and permissible for the ET to take the narrow pool. We've covered a lot of the reasons, so you can anticipate this, but we say that was the only pool in respect of which the respondent had produced evidence that the PCP was in fact applied. So the respondent, for example, never provided direct evidence which said that the catering contract was also negotiated. These are the terms of the catering contract. This is what it says about hourly rate, and this is how the Royal Parks directed that term be incorporated into the contract. Or this is how the Royal Parks.
It's very unsatisfactory. I mean, it's why the pleading point may be more important than I thought at first. It's very unsatisfactory. You say they didn't produce any evidence. They might say, well, you didn't ask for any evidence. I don't quite know who the burden is on.
Well, would I say that in a case like this, when one party, it's on them for two reasons. Number one, they are the only party with possession of all the facts.
But that
So they
in
have
a principled way, I'm afraid that's not normally how the burden of proof depends. If the burden of proof is logically on the claimant, but they don't have means of proving it, then there are various procedural tools for you to ask them the question so you can prove it.
Yes, but as you'll have seen from that email correspondence, the reason they withheld the documents is because they took the view that they weren't relevant. Well,
That's a bit of a debating point. I'd like to know who formally the burden of proof was on, you are asserting a particular pool.
Yes.
I would have thought that the burden was on you to prove that the pleaded PCP was applied to that pool. And if you weren't in a position to do so, you'd have to ask for discovery or ask for further information. But it might be said that if the respondent says a different pool is appropriate, it should be for the respondent to prove the facts which show that the PCP, if it, they could save their position on whether it really was a PCP, but the PCP alleged actually, if it was a proper PCP at all, applied to a wider pool, then they'd have to plead that and they'd have to prove that. So that's a point in your favour, just thinking that. But it is very unsatisfactory that no one really grappled with the implications of this, apparently. Whether we don't even know if there are any case management conferences, almost certainly are in a case like this.
There were, but none of which.
None of this really
issue-
emerged. No, well, that sometimes happens. Okay. Well,
There were two reasons. Did you state them both, or did you just state the first?
I just stated the first, my
Right.
lord. I think stated the second. So the first was you have to ask yourself who has possession or control over the documents, and that's entirely the respondent. And the fact that it makes a calculated choice not to disclose them when it has a duty to disclose relevant documents.
is that's the second point, is it now?
No, this is the
Okay.
first point. Both parties have a duty to disclose relevant documents. If it chooses to withhold them on grounds of relevance,
Well, we've got to be aware that tactics cuts both ways. Tactically, it may have been very much in your interest to keep the small pool.
I mean, we
But
simply
equally,
don't know.
and tactically, it may have been in their interests. You say if they had a big pool that was much more representative, just to show it.
Yeah.
To say these people who are not predominantly ethnic minority workers have got the same treatment. And they could have done that.
Yes.
And what's your so that's a further point under your first reason. What was your second reason?
The second reason was the one you alluded to, my lord, which is,
Yes.
well, if someone wants to posit a different pool and say other people should be in that pool, then it's for that party to prove why those other people should be in the pool. There shouldn't be a starting presumption that there's no entry to requirement. You've got to show why those people should be ruled in.
I mean, do you take it so far as to say that, considering the statutory purpose, that to put people in the position of your clients, to having to get the pool right from the get-go, creates really unrealistic difficulties for them, even if they're represented both by unions and by lawyers?
My lord, yes, it becomes. I say the burden is too onerous to require claimants to do the running on every, especially when a respondent hasn't nailed its colours to the master pool, to do the running on every conceivable pool that it might or might not put forward.
Well, that respect is obviously right. But but I would take some persuading that it wasn't for you to come clear from the start about what your pool was, and to be prepared to prove it, and to get the documents or information to do so. And the problem here, I'm repeating myself now, is actually that the literal way you pleaded it was a wide pool, and you never pursued the evidence to establish that. To which your answer is, well, if you read it properly, that wasn't a wide pool, it was a narrow pool, it was only the toilet and cleaning workers. And nobody appears to have thought any different until day 3 of the hearing.
I could make.
Well, yeah, but yes, go on. Yeah.
I could make one point, and I appreciate this is not in. I don't think it's in our skeleton. When you're looking at statutory purpose, I think it's also relevant to have regard to the shifting burden of proof and discrimination claims generally, section 136, and how the law recognises. Often, I accept, raised as a point in direct discrimination claims when the court recognises the challenges of inferring things. But I say it's also relevant in an indirect case, and the issue is that if discrimination could be inferred from a set of facts, then the burden shifts to a respondent.
The problem that I got is I'm not even sure that it is the pool that's the question. The question is, what is the PCP? And then once you've identified the PCP, the pool is all people to whom the PCP are applied. That's what you have to do. And that is on you, isn't it? Section 19, a person A discriminates against another person B. If A applies to B, the provision, criterion or practice, which is discriminatory in relation to a relevant protected faculty. You've got to identify the provision, criterion or practice, and we have to decide whether or not you were saying they treat direct versus outsourced workers differently, full stop, and then the pool will follow from that, or whether you're saying, you know, they treat direct workers and this particular group, the Vinci contract group, differently. That's what we've got to decide to start with, really, isn't it?
Yes, my lord. I could make just a couple of broad points. We say it's a matter for this court how it says the pleading should be fairly read. Our position is we pleaded a narrow pool, and that's how we channeled the case. The second point I make is if this court were to find that we pleaded a wide pool, then the question is, what was the evidence before the tribunal, and did that evidence, even looking at it through a wider lens, come down to the same 160 employees and 50 contractors?
No, it would be 160 employees, and the starting point here would be all the outsourced workers. I forget how many there are, and it may be that like most of the cleaning outsourced workers are black British or minority ethnic British. When you take all the other ones, the figures would be less, and you wouldn't be able to establish that it puts a person of an ethnicity at a disadvantage. That's the problem, that's the starting point. Unless you can show that being an outsourced worker puts you at a disadvantage and you're more likely to be BME, you don't get onto the other things.
I mean, that.
Well,
Anyway,
I think we probably explored this as far as we can. Don't promise we may not think about it overnight and put some more questions on it, but I think it's been very thoroughly explored. We're obviously about to rise. How much more have you got to do? You've covered most of the ground, I think.
material,
Yes.
applied.
But what applied, you've really dealt. You haven't.
I do have, I would suggest,
But
I'll do my best to finish off the remaining points within an hour or so.
yes, I think that will be fine. The person who's coming second always has less work to do in terms of time, because a certain amount has been refined by that stage. Well, Mr. Milford, you won't have any difficulty if you're on your feet by 11:30 tomorrow.
Not at all.
Well, thank you very much. I'm sorry that we can't go on this afternoon, but I think we wouldn't have finished anyway, so no harm is done.
Can I check what time we're starting tomorrow then?
Well, if there had been, 10:30 is the answer,
10:30.
but if there had been a difficulty, we might have been prepared to sit at 10, but it doesn't sound as though there will be any, so no, it's just 10:30 in the usual way. Can I just ask one other question? We've got your closing submissions to the tribunal. You told us that you had short written opening submissions.
Yes.
I think for completeness, I wouldn't mind seeing
Fine,
those.
fine.
Were there any written submissions from Mr. O'Dempsey?
Yes, they're in the.
Oh, they are. I'm sorry.
Supplemental bundle.
That shows how.
But there aren't any opening submissions from him.
No.
Closing.
That's correct.
Yeah. You said you didn't do opening, did you?
I beg your pardon.
You didn't do opening written submissions, you said.
No, and that would be
So-
expected.
Mr. O'Dempsey's closing submission.
I'm sorry. Yes, I hadn't really grappled with
Read.
those, but I see.
And then he also gave submissions in reply to our closing submissions.
Sorry, wait, hang on. Having beat myself up for not having read them, where are Mr. O'Dempsey's closing submissions?
So supplemental bundle, page 3, running to page.
No, page 3 says closing submissions.
I beg your pardon.
There's claimants closing submissions.
Well, the respondents first. 3 to 20 respondents. And then 21.
Oh, I see. I'm sorry. Yes, the index is misleading.
Yes.
Yes.
The index is both sides submissions. Well, I'll make sure I read those overnight.
So the two bits to his. There's the ones the longer version, which start at page 3, and then
31.
the reply, which starts at page 31, which is shorter.
Wow. How did this work? How did this work? You both
So we exchanged.
you
written
both
submissions.
you both sat up all night. Mr. O'Dempsey, I see, told us that I see. Yes, you exchanged in the overnight. And Mr. O'Dempsey got up early and did a reply to yours, which timed at 10:46. Well. But these were obviously written, but they were spoken to then as well. Thank you. Well, that's something for me to read.
All right.